So if you've been following the videos that we've been putting out on managing contractual risks, then the one thing that you really start to realize is that when you make a contract, the intention of the parties is very important. And so if you're trying to manage a risk in a contract, then you always have to understand whether the party intended for the contract to be legally binding or not. I mean, here's why intention is important. An agreement may not qualify and may not even be considered as a contract if it lacks certainty, which is simply to say that the terms and intentions of the contract need to be clear to a reasonable person with no prior knowledge of the context. See, when you're contracting, what you have to understand is that when you get into a business deal, or when you get into a contract for that matter, during the negotiation phase, before you even get into that contract, you're going to say a lot of things, okay? Most of these things you're just saying them because you want the party to get into the deal with you. So they are pretty much what we call representation. And you don't really intend to be bound by those things. And so your intention becomes important. And so does the intention of the other party. At what point are you saying something that you intend to be legally binding? At what point are you saying something that is actually a mere representation? So it is important to understand whether the party intends to have a deal with you or not. However, the extent to which certainty is required for an enforceable agreement will depend on the circumstances of each case. For instance, you could be supplying ink in a school, okay? And they never really told you the quality of ink they want. They pretty much told you the color, and that's it. And so at that point, quality, and by quality I mean there are many companies that make ink and, how thick is it, how light is it, so that kind of stuff. But down the line, the school may change their mind and tell you, look, now you want this type of ink. And at that point, quality becomes a certain term in that contract. So certainty of what you are agreeing on in a contract could vary, but there has to be certainty that we are agreeing that the legal consequences should follow. So, how do we determine certainty? Well, in this video, we find out. So look, if you're new here, hi, I'm Moses, the founder of Zerite Network, and I'd like for you to subscribe to this channel and hit that notification bell to be notified each time we upload a new video. And this is an educational channel, so we have more than just contract videos. We have business, we have finance, we have development related. The point is we have a bunch of videos. And so I'd like for you to subscribe. Now let's talk about contracts, okay? Let's continue what we're talking about. Now there are two factors to consider when you're talking about certainty in a contract. And these are vagueness and incomplete agreement. So let's start with vagueness. When you're talking about vague or vagueness in a contract, this can be seen through terms or rather through wordings like best efforts, reasonable efforts, as soon as possible, etc. All of which don't really tell you what to expect now, do they? If a contract is looked over and no definitive meaning or intention can be understood without altering existing terms or adding new ones, the contract may be deemed to be too vague to be enforceable. And so when you're dealing with such risks, you have the following options, okay? So these are how you manage your risks in relation to those contracts. You have the following options. Number one, using reasonable measures that are available. So if, for example, delivery is the problem, okay? The delivery thing is a bit vague. And so you can use your previous experience regarding such a contract to fix that problem. So we can compare delivering schedule from past contracts and apply to that contract. Number two, alternative dispute resolution mechanism. The point of alternative dispute resolution mechanism as part of managing contracts is that you are really trying to make sure that litigation, basically lawsuits, become the last resort when you're dealing with contract. The idea of taking somebody to court straight away is not always a good idea because look, when the two of you go to court, the true winner in this case is the lawyer because these lawyers are paid irrespective of what happened. And yet the litigation process is actually going to be zero-sum. One party is going to win, another party is going to lose. So what guarantee do you have that you're going to be the winning party? So before you jump into litigation, try and use alternative dispute resolution mechanism. You're talking about things like negotiation, okay, arbitration, reconciliation, mediation, all that stuff. Incomplete agreements. One of the things that I'm always fascinated by when talking to people and we're discussing contracts is how they're always under the assumption that a contract contains every imaginable risk and a solution to it. They look at contracts as if contracts have everything. The truth is, nope, they don't, okay? Contracts can be incomplete. A contract doesn't have to cover every imaginable detail, but it should cover key areas and terms or address them in some way. So what you have to do here is that you always want to look at your previous contracts or previous dealings you've had with other partners and see the problems that you had and make sure they're fixed in a new contract. Of course, I do understand that sometimes it's the first time you're getting into a contract and therefore you might be a bit foggy on the details. But either way, it's always important to have, or rather to make sure that you have your details expressed in that contract. Okay, you have all your fears. Okay, first of all, make a list of the things that you think could possibly go wrong and then try to discuss them before you get into a contract. In a case where you're both new to a contract, it's a good idea to have a clause which states that the parties will look to complete any details as soon as is reasonably possible. Otherwise, you just end up with an incomplete contract. Plus, having such a clause also reaffirms your intention to get into business or to make a deal, because you're saying, look, I want this contract to exist, okay? I want to have a deal with you. And if there is any problem in future, I'm also open to trying to fix it, okay? So to conclude, let's talk about this case, Blue v. Ashley. So this case concerns an action that was brought against an entrepreneur, in this case, Mr. Ashley. Mr. Ashley was pursued by a business consultant by the name of Mr. Jeffrey Blue. Mr. Blue alleged that he had been employed by Mr. Ashley's company, Sports Direct Group, to provide business consultancy services. The evidence of Mr. Blue was that at a meeting in a pub with Mr. Ashley and 3 other representatives of Sports Direct, Mr. Ashley, after drinking at least 8 pints of beer, had promised to pay £15 million bonus to Mr. Blue if he could ensure that Sports Direct's share price moved above £8 per share. It was common ground between the parties that the meeting in the pub had been an informal social setting. Mr. Blue alleged that Mr. Ashley had nonetheless made him an offer, intending to be bound by legal relation, and that Mr. Blue had accepted that offer. Subsequently, the share price of Sports Direct did indeed rise above £8 per share. When Mr. Ashley refused to pay Mr. Blue the £15 million, Mr. Blue issued a proceeding in the High Court to recover the sum. So what do you think really happened? What do you think the outcome in this case is going to be? So let's talk about the outcome. Giving judgment in High Court, Justice Legat dismissed Mr. Blue's claim. This was on the ground that the parties had not intended that Mr. Ashley could be legally bound by his rather extravagant promise to Mr. Blue. The judge made a number of observations, the main one being that an evening of drinking in the pub was an unlikely setting for formal contract negotiations. Further, it was not actually within Mr. Blue's power to achieve the aim of increasing the share price above £8. Finally, it would have been out of Mr. Ashley's character in any event to make such a promise. Consequently, the judge concluded that, considering the predominantly social nature of the meeting, when he applied the necessary objective test, then the only reasonable conclusion was that Mr. Ashley's statement had amounted to no more than mere banter. As much, Mr. Blue could not rely upon Mr. Ashley's statement as a binding contract. So it's always important. So looking at that, obviously there was no deal based on the context and based on the parties' behavior. So it is important for you to take all those factors into consideration when you are contracting, okay? Intention is important. Remember, offer plus acceptance will give you an agreement, okay? You add consideration, well, you may have a contract if you also add 2 other things: intention of the parties involved and legality. So if you have any question, do let me know. I'm Moses from Zerite Network, and I'll see you in the next video.